Welcome to the North Carolina Department of Justice's rules and laws around property management in North Carolina. That sounds super boring, doesn't it? Let me try to spruce it up. Let's jump into a quick, straight to the point video on the amazing rules around the responsibilities of landlords and rights of the tenant. I'm Sean Kelly and I launched a vacation rental property management business around the Lake Norman, North Carolina area and thought, what a better time to create some content around this area. So I'm creating a wish list property management playlist on this YouTube channel that deals specifically with property management. Part of this new content will be my intention to give back by doing free handyman work, monetary means, or other methods to try to give a good name back to property management and landlords and nix that slumlord stereotype. Also, if you need management services around this area, then definitely hit me up. I do not commingle my property management business with buying and selling, so any referrals that come to me as far as management goes, I will give those clients back to you when they plan on selling or buying another house. I'll also have this video in a written format on my website, so if you prefer reading over video and listening, then check that out too. As a property manager in North Carolina, it's important to understand the various laws and regulations that govern your profession. In this video, we'll cover some of the rules and laws that you need to be aware of. And if you're taking the real estate exam, this will be crucial for you as well. So there are a few acts to know. So first you have the Fair Housing Act, which you learn a ton about in real estate. Then you have the North Carolina Residential Rental Agreement Act, and then the North Carolina Security Deposit Act, and then the Vacation Rental Act. As usual, I'm going to try to throw up some pictures and videos on here to make this a little bit more appealing than just having me talking to you. First, let's talk about the Fair Housing Act. This federal law, not just state level, but a federal law, prohibits discrimination in housing based on race, color, national origin, religion, sex, familial status, and disability. As a property management, it's really important to comply and understand the Fair Housing Act so you can be sure that you're not discriminating against your tenants. And plus, these are just rules that probably make you a better human to begin with. But you'll seriously need to memorize this list for the exam if that's why you're watching this. But basically, don't discriminate, period. I can't put up a sign that says, no Irish need to apply. To put this in perspective of a property manager, it may be really tempting to Facebook stalk an applicant that comes in because you may be thinking, well, you could just get a better feel for their job and their lifestyle and make a better decision. But this is actually extremely dangerous because you could end up making a biased decision based off of some opinion that they've posted online. Maybe you're a big fan of the color blue and they have the color red, or they have some flag, or they have a political view or whatever, and it could sway your decision making on there. And this would be a biased decision and not in the best interest of your company as a property manager or that client's home. Other ways to avoid getting in trouble with discrimination is to set your standards in the first place and follow those to a T throughout the hiring or application process. This is another example that I've heard throughout my real estate investing career, is that you never let a tenant slide on a late payment fee. Now, this may seem extremely rude, but hear me out. If you let one tenant slide because they're nice and because usually they pay on time or whatever reason, you just feel good that day and you don't want to charge them a $25 late fee. But then you have another tenant over here that you do charge a late fee for. If for whatever reason you were to go to court outside of the late payment fee, just for whatever reason, and it were to come up that you charge this tenant a late fee, but not this tenant, boom, you're hit with discrimination and you could lose the entire case, right? This tenant that paid the late fee could destroy your entire $10,000 kitchen, but then they're suing you for discrimination because you charge them a late fee, but not this person over here. Set your standards and stick to them. Next, let's talk about the NC Residential Rental Agreement Act. This state law sets out the rights and responsibilities of landlords and tenants in North Carolina. It primarily covers issues such as complying with building codes, providing a property that is fit for human habitation, and eviction types due to the negligence of the building or contract. If either the landlord or the tenant breaks this act, the other party is automatically excused from their responsibilities. Basically, the landlord must provide a livable space and the tenant must keep their private area safe and clean, trash disposed, plumbing fixtures clean, and so on. Normal wear and tear is okay, almost like if you buy the extended warranty at Best Buy. This act is more about the property itself rather than the relationship between the landlord and the tenant. Finally, let's talk about the North Carolina Security Deposit Act. This law sets out the rules for the security deposits in North Carolina, and much of the country has identical rules, including how they must be held and how they must be returned and what deductions can be made from them. In other words, it's the legal equivalent to a savings account for your tenant security deposit. So don't go out there as a property manager and blow the security deposit money on Domino's Pizza. In regards to a security deposit, a landlord is allowed to take up to 2 months rent for a security deposit amount. So that means if the rent is $1,000 a month, a landlord can charge $2,000 in a security deposit. For week-to-week rentals, you could charge up to 2 weeks for a security deposit. For month-to-month leases, you could charge up to 1.5 months for a security deposit. And again, for anything more than month-to-month, you can get up to 2 months in security deposit. Literally just got off the phone with one of my tenants. They want to reverse one of their monthly payments and then pay it last minute. Interesting times. Anyway, a landlord must hold their security deposit in an interest-bearing separate account that does not commingle that security deposit money with any other personal money or business money, like operating expense money. Then that money must be returned to the tenant within 30 days after that tenant moves out of the property. The landlord can make deductions from that security deposit to pay for unpaid rent or damage to the property, but they must provide the tenant with a written, itemized list of any deductions. Again, normal wear and tear is not covered by the security deposit. That is on the homeowner to fix. And then once again, let me reiterate, the security deposit must be held in a separate escrow account where you cannot touch it until it's time to pay damages or mystery from the tenant or give it back completely to the tenant. You cannot commingle, that's a key word for the exam, you cannot commingle that money with any of your other money. You can commingle that with other security deposits. Like if you have 5 properties, you could put all of those 5 security deposits in one security deposit account, one escrow account, but you can't commingle it with your personal funds or other business funds. And the purpose of that is kind of common sense. You don't want that property manager or even just a personal, if you were to rent out your own home and you weren't a real estate agent or property manager, you still must have that money in an escrow account because they do not want you blowing that money in Vegas. That is still your tenant's money. And then if you're asking, what is that normal wear and tear? Well, I have a list for you here. It's worn or dirty carpet, faded paint, dirty windows and walls, broken curtains, leaking faucets, small nail holes in walls where they're hanging their pictures up, and things like that. Things your deposit can cover are like crayon marks on walls, large holes, broken windows, stained carpet, and just a really filthy unit. Then finally, there is the North Carolina Vacation Rental Act, which is on, of course, vacation rentals. A vacation rental is defined as a property where somebody stays for less than 90 consecutive days. Under the Act, property owners are required to register their property under the North Carolina Department of Revenue. Owners are also required to collect and remit the state sales tax and any applicable taxes on the rental income from their properties. Most of the previous acts I've discussed in this video also apply to vacation rental homes, but there are a few exceptions. The security deposit must be returned to the tenant within 45 days after move out rather than 30 days like in a long-term rental. And the security deposit can be used for other things like long distance phone calls and other services that they might buy.
Maybe we should put on a dirty movie.
Lee!
One of the biggest things I come across in the vacation rental world is where if the homeowner of that vacation house decides to sell that property, the new buyer must uphold all of the leases that are within 180 days of that sale date. I sold my vacation property on Beach Mountain just this past June, and the new owner had to honor all the bookings that I had through that summer. Another important difference is that the eviction process is much shorter in a vacation rental. You do have 4 hours to get a tenant out of that house. There's a 4-hour notice to vacate on a rental property, and I'll have a whole nother video on the eviction process for both long-term rentals and short-term rentals. Which brings me to my last general rule here, which you'll need to memorize, and this is the eviction process timeline. If the lease is coming to an end and the tenant is squatting, then you must provide a 2-day notice for a week-to-week arrangement, a 7-day notice for a month-to-month arrangement, and then again a 1-month notice for an annual lease. And this is not an eviction notice yet. If you are just straight up evicting somebody because they didn't pay the rent or broke some other rule, then you must provide a 10-day notice to evict. This is an eviction notice. And in conclusion, as a property manager in North Carolina and really anywhere, it's extremely important to understand the laws and regulations around your profession. By doing so, you can avoid the legal problems and provide a fair and safe living environment for your tenants. And hey, maybe you'll even learn a thing or two on the way. I mean, not me, because I know everything. I hope you learned something today and stayed awake. Please remember to hit that like button as a free way to show your support. Ask some questions down in the comments, and I will see you all on the next video.